I wish to categorically state here that although this matter has been pending for a considerable period of time, the evidentiary record before the court remains minimal. The prosecution lined up a total of 36 witnesses as per the inventory filed herein. However, they have only called 6. There is much to be covered in terms of the evidence intended to be adduced by the intended witnesses. At the same time, it is my considered opinion that the prosecution will not be filling any gaps and that the defense shall not be prejudiced in any way, since they were served with the written statements of the remaining witnesses and shall also have a chance to interrogate their testimonies and or evidence during cross-examination. This lays a basis for the need for this court to adopt the finding of the learned judge in the above case and to invoke the provisions of Section 150 of the CPC, and further, to ensure that all relevant evidence is placed before the court. In another case of Pans, Karunzi, and 16 others versus the Republic, the court held that reopening may be allowed where, number 1, there is new or crucial evidence, and number 2, reopening will not prejudice the accused person or amount to filling gaps in the prosecution case. This decision underscores the importance and or the need to reopen the prosecution case where the evidence is material and necessary for the ends of justice to be met, not merely to repair a weak prosecution case. It is important to note that the weakness and or the strength of the prosecution case in the present case is yet to be determined, and therefore an order to reopen the same shall not be for purposes of repair or as stated above. Option number 4, the court is allowed to order the prosecution to proceed with the available witnesses. If the witnesses are actually present in court, the magistrate or judge may simply direct the prosecution to proceed and call them, especially if the closure was made prematurely or in error. In the present case, since it has been established through the submissions of the IO and the EACC Council, together with the averments of the IO in the affidavit sworn on the 24th of March 2026, that there are witnesses who are available and ready to appear before the court to testify, this court shall proceed to give precedence to options number 2, 3, and 4 above, because the primary objective here is substantive justice rather than technical acquittals. In conclusion, therefore, it is my considered opinion that the application by the prosecution to prematurely close its case is misconceived, ill-advised, and misleading. It is hereby declined. That is the ruling of the court. Parties are granted 14 days right of appeal.